Johnson, sign today's order and get a copy of that at the window outside the department and to your left. I'm gonna wish you the best of luck with that. Hopefully that'll all work out. Thurston County is sometimes pretty easy to deal with. Good luck to you.
I'm hoping I can get a car and get the blow and go and then license back.
And get back on the road. That was, hey, in time. You will in time. Just don't give up.
Yeah, never. Thank
Take
you so
care.
much.
And you as well. Michael Shore. Mr. Shore, good morning. How are you?
Morning. I'm doing well. Thank you.
Um. And the docket entry I have here, the concern is proof of domestic violence treatment and mental health treatment. Where are we with that?
There should have been an update from Best Counseling Services, who is doing the DV treatment. I've attended 4 classes weekly now. The mental health is as well. I've been doing that since November with Dr. Sutton.
The most recent thing we have is dated is April 24th. If you've been doing, we should have something substantive to that. Does it need to offer best life? That's the most.
Yeah, they, well, I can look, but she was supposed to update both Yelm and Superior. Superior got it.
Excuse me, you're on their hook as well. That's
Yeah, in fact, Superior's order is gone. It finished on the 31st. So, yeah, I'm doing the weekly classes in treatment with the DV treatment, and it's actually it's nice, the weekly reminders, different ways of thinking. So it's helping a lot.
it is helping. That's the important thing. You know, these agencies, they're really good about helping, most of them. They're maybe not so good about filing paperwork with the courts. The treatment with them pretty much comes first, and sometimes this just kind of gets lost in the shuffle.
Right.
Why don't we reset the matter out about a month to
Okay.
give you a chance to get this on file here, and if we get the right updates, what we'll do is strike the hearing.
Okay.
Why don't you do this? We'll give you a court date, and you might check with us shortly before to make sure that we have gotten
Okay.
and it's sometimes the best way to approach it is to tell the agency, say, I'll take care of it. Sometimes they'll let you, but sometimes they want the reports to go directly to the court, so they are edited in any way,
Okay.
shape, or form. So
Okay.
that they're not being.
That's understood. I might have given the Yelm probation email. I don't know if that gets transferred over at all, but yeah, she said she sent them, so I'll ensure that she sent it. Dr. Sutton's working on, I don't know, she's working on a 2-page evaluation of sorts to give to Superior, but that's.
Oh, I do have that. And Dr. Sutton did send a letter saying you were starting, you were going to begin November 30th, but then nothing after.
Okay, okay.
We need a confirmation that you wouldn't believe how many times she said, I'm going to begin on this date, but that never happened. So we just, as a matter of housekeeping, just want to confirm.
Okay, I'll make sure, and then I'll make sure that it's received then by talking to them or calling them.
Perfect.
Here.
Perfect. July 6th be the next date. Mr. Redfield, anything to add? That's it.
But I am for sure doing it. I wake up at 3 in the morning and then I'm up till 9. I was there last night. So you know, I'm for sure doing it because I'm definitely not sleeping.
That's
Should be.
I want to make sure you get your sleep. That is the best medicine.
Absolutely.
No, you're doing the best you can, and And the real important thing is, yeah, other than your sleep, how is life going otherwise?
Really good. I think I'm, taking to heart the practicing some breathing techniques that Dr. Sutton's given me. Just kind of having a more neutral, part of the problem's been, I've taken emotion and put it in a box so I can conquer something, right? And Dr. Sutton's like, no, then you're not processing and growing.
You've gotta process.
Right. So it's sounds complicated. It is getting used to it.
It's something to learn.
It's helping out a lot, the tools, so helping out a great deal. So
That's, as long as, she's giving you the tools to help deal with things. What's worked for me is to just resign myself to the belief that, don't sweat the small stuff. And ultimately, it's all small stuff. So, yeah, just relax, take it easy and live life.
absolutely.
Well,
Thank you.
Mr. Sharp, it's good to see you. I'm signing today's order, resetting the matter to, the 6th of July
Six. At 8:15.
at 8:15. Don't need to write that down. Get a copy of today's order by going to the window.
And if the documentation comes in appropriately, then.
Absolutely, yeah. Make sure, yeah, I don't want to drag you in here for just to tell you it's, hey, good. It's, I'm sure you have better things to do than sit and listen to me bark, so.
Okay.
But you, Mr. Sharp, it's good to see you. You take care of yourself and,
Thank you.
We'll just see how it goes.
That sounds great. Thank you, Your Honor.
Take care of yourself.
You as well.
I will.
Enjoy this summer.
We have to. That's it for the 8:15 calendar. Sir, you on the,
Well, sir, if I may,
yeah,
what had happened, I got it, my name is Morris Brandon, and I received a letter, be here day 8:15, due to the fact that, my, project report wasn't being sent from the VA, so I'm here to find out, if they, am I supposed to be here, or did they start sending it? And the supervisor name is, William, Matthew, from the VA.
not on the docket, but let's check into that, make sure we have what we need to have. And
Yes.
they received proof on 19th, and that lets you off the hook, but good to have you here. Anything, how's life going, as long as you're here?
That's one fine, sir, one fine. Okay, got plenty of AAU going on and stuff, so far, everything is looking up and,
Living life.
I do the best I can with what I got, sir.
It's always, yeah, that's, I think it was T.S. Eliot, the English poet. I try to live by his, axiom that we do the best we can, the rest is not our business.
Yes, sir. Yes, sir.
Hey, but you take care of yourself, you have a good day.
Thank you, sir. You guys too. Thank you.
Thank you. And with that, we'll go off record, unless we have the jail on here.
No, we've got to start the. Oh,
Mr. Abaco, good morning.
morning, Judge.
We'll address the in custody calendar at this
Okay,
time.
Judge, this is, so we'll start with, item numbers 1, 2, and 3 on the 8:30 in custody calendar. This is Amanda Ann Marie, is it Westus? Hustis, okay. And I've had an opportunity to discuss her various matters with her. She has 3 matters on this morning for arraignment. We discussed what an arraignment is, which is usually a time to enter not guilty pleas, be read the charges in court and the maxims that could be imposed. She'd like to take care of these matters today. In order to do that, we'd like to waive arraignment, formal arraignment. She understands her rights for that. And I prepared a statement of defendant on plea of guilty for her. We've gone over the cases. The city provided me a copy of the police reports. I've had an opportunity to discuss those with her. So I anticipate she, on the item number 1, she's going to enter straight pleas, theft, third, and obstructing. On item number 2, theft, she's going to plead to that. And then I think the city was going to dismiss item number 3 and dismiss that theft charge. So plead to 3 counts and dismiss 1. And the recommendation was at a time served, no fine, and hopefully Your Honor will release her today.
Good morning, ma'am. For the record, is your full name Amanda Ann Marie Huestis?
Hustis,
Do you disagree with anything at all your attorney just said?
no. I do want to say one thing, Your Honor. On one of my charges that I don't talk about that. Okay, never mind.
We'll get to that in a minute. What I do want to tell you is that I really don't like to hold people in custody, but after all the issues we've had, I felt a small amount of bail would be the only way of getting you before the court at all. I want to make sure you understand that. In any event, I'm looking at a statement of defendant on plea of guilty to 1 count of theft, third degree, and 1 count of obstructing a law enforcement officer alleged to have occurred on September 3rd, 2022, and 1 count of theft in the 3rd degree alleged to have occurred on August 14th of 2022, all within the city of Yelm. Have you gone over the statement on plea of guilty with your attorney and gone over the process?
Yes.
And if you had any questions at all about what that process meant,
Yes,
were your questions answered?
yes,
If I accept the plea, you give up the rights contained in paragraph 5.
yes,
Trial, no appeal, simply a sentencing which could be up to the maximum, and that would be 364 days incarceration and or a $5,000 fine on each charge.
yes,
With that in mind, as to 1 count of theft in the 3rd degree and 1 count of obstructing a law enforcement officer in the performance of his duty alleged to have occurred within the city of Yelm on September 3rd, 2022, and 1 count of the theft in the 3rd degree alleged to have been committed within the city of Yelm on August 14th, 2022. How do you plead, guilty or not guilty?
guilty.
Make those pleas of your own free will.
I am.
Anybody make any threats or promises to you to make you plead guilty?
No,
I will find the pleas to be freely, knowingly, and voluntarily made, and your statement of paragraph 11 does satisfy the factual elements. The recommendation is for all jail time to be suspended, and no fine is to be imposed. Is there anything you'd like to tell me?
I wanted to say that one of my charges, Lloyd Schaefer had nothing to do with it. It was all on my accountable. One of my charges, I chose to do what I did. He wasn't liable for it. I wanted to make that note. I promised him I would say something. Lloyd Schaefer had no clue what I was doing.
We're not dealing with that at this time.
Okay,
I'm gonna, Mr. Hatfield, anything to add? Mr. Haverco, anything to add?
Oh, nothing to add, Your Honor. Just would ask court to follow the recommendation. Thank you.
This was, I'm going to follow the recommendation, impose 364 days concurrently on each charge. Suspend all jail time on the condition you simply have law-abiding behavior.
I promise I'll be good.
Pardon?
I said, I promise I'll be good. I've been working with Sidewalk for Homeless People and I'm trying to get back to the community. Since then, I found some help to be able to get food for me and my child and to stay out of trouble. So I'm trying to get back to the community right now. I'm working with Miss Susie. She is Sidewalk for Homeless People and I go and I help out other people that are citizens like me. So I'm helping, trying to get back to the community for the wrong things that I've done.
This
I'm
was,
trying.
wish you the best of luck with that. Don't give up. That's the important thing. Don't give up on yourself, okay?
Okay,
Try, do the best you can.
okay,
Nobody's perfect. Life isn't perfect, but you just do the best you can, okay?
all right.
Send
Thank
out the orders on today and you'll be free to go on the, on these charges, and you'll be free to leave in the jail unless you're being held on some other matter.
No, I'm not. Thank you.
Hey, Ms. Westis, thank you. You take care and good luck to you.
Thank you. Yeah, my husband's waiting for me. Now I'm gonna call back and tell me I'm selfish.
And for the record, ticket and number 7312 will be dismissed as part of the disposition. You have a matter with council here, Mr. Radfield, anything that can be handled very quickly. We're in a little bit of a pause with the,
Good morning, Your Honor. For the record, Seth Chinning of Puget Law Group on behalf of Mr. Brody Bennett. For attorney of record, Mr. Chris Kattenhorn, I'm appearing on my client's behalf pursuant to Rule 3.4. There is already uploaded to courts a motion to continue. And
July 20th, 2023 at 9 o'clock.
that's the one, Your Honor.
Ms. Radfield, any objection? Motion granted. I'm signing an order resetting the matter to July 20th, 2023. Client here, are you in touch?
No, Your Honor.
In
Appearing-
touch with your client?
Yes,
That's,
I haven't been, but Mr. Kattenhorn has.
that's all that matters.
I felt the need to make sure I parse that out because I have not been.
Signing the order as well, clicking on the order as we speak.
Of course, Your Honor.
Signed and now closed. Matter's been reset. Get a copy of today's order by going to the window outside the courtroom to the left. You take care and have a good day.
Thank you, Your Honor. Always a pleasure.
Likewise. You know,
Mr. Wilcox. How you doing, sir? Good to see you. Good.
Thank everybody here for their patience. We have to go back on for an in custody matter. Have a go. I see you've gone back live anytime.
Oh, okay, Judge. I was, I was waiting on your honor. This is James Wilcox. He's got a compliance matter. Item number 7 on the calendar, and then he's on for arraignment on item numbers 8, 9, 10, 11, 12, 13. A lot of these are they are sub numbers, as I understand it. I have had an opportunity to discuss these violations with Mr. Wilcox. They all stem from contact related to the children that are protected persons in a civil protection order. I think the parties have a proposed resolution, which is he's going to, as your honor can see from the plea statement, he's going to plead to essentially four counts of violation of protection order. City felt that was sufficient, and upon the court's acceptance of those pleas, the city would be moving to dismiss all the remaining charges. And the nature of the recommendation is time served. I did review with Mr. Wilcox, again, the police reports and the nature of the charges. He understands what the new charges are, and we discussed what an arraignment is, to be read the charges in open court, the maxims that can be imposed. He would like to waive that procedure, waive formal arraignment, and proceed with the entry of straight pleas as indicated in the statement of defendant on plea of guilty, of which I have reviewed with Mr. Wilcox. And so I would ask your honor to inquire.
To clarify, the city would be willing to dismiss docket numbers 8 and 9 and the remaining counts, but for violations with regard to docket number 10, et cetera, et cetera. Mr. Redfield, is that correct? Is your name James Arthur Wilcox?
Yes, Your Honor.
Did you agree at all with anything your attorney said?
Yes, Your Honor.
I am appointing Mr. Aberco to represent you with regard to all matters on today's docket. He indicates that I understand that the city is going to take no action with regard to docket number 1. That's compliance with a data violation resolution back on 10/10 of 2021. City's likewise willing to dismiss docket numbers 8 and 9, violation dates September 16th of 2022 and September 2nd of 2022, in exchange for a plea to 4 counts of violating a protection order on May 19th, 2023. Is that correct? Do you agree with that?
Yes, Your Honor.
And you're going to waive the formal process of arraignment and proceed to a disposition on that basis?
Yes, Your Honor.
Your name is James Arthur Wilcox?
Yes, Your Honor.
I'm looking at a statement of defendant on plea of guilty. Tells me your age is 49.
Yes, Your Honor.
Have you gone over the plea process with Mr. Aberco? And if you had any questions at all about what it meant to enter pleas of guilty, were your questions answered?
I don't have any questions, Your Honor.
If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which could be up to 364 days and or a $5,000 fine with regard to each charge. You realize that?
Yes, Your Honor.
With that in mind, as to 4 counts of violating a order of protection within the city of Yelm on May 19th, 2023, how do you plead, guilty or not guilty?
Guilty, Your Honor.
Do you make those pleas of your own free will?
Yes, Your Honor.
Anybody make any threats or promises to you to make you plead guilty?
No, Your Honor.
I will find the pleas to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 of the plea form does satisfy the factual elements. Based on the recommendation, Mr. Redfield, anything to add? Mr. Haverco, anything to add?
No, Your Honor, I'd ask the court to follow the recommendation. Now you realize he understands the predicament he's in, and we had a conversation about what are the kinds of things will need to do to have future contact with his kids. Just for Your Honor's information, I mean, a lot of this contact wasn't threatening contact as between him and his children. He was prohibited legally from talking to them. They wanted to talk to him. That's not a defense or an excuse, but we just talked about what the legal process would be to try to, get back to court in the original civil action, which is the appropriate place in order to do that. And I believe also believe the protection order, while it remains in effect for a good while longer with the ex-wife, I believe it expires much sooner for the children. So I think it expires, this coming November, so anyway. Just ask the court to follow the recommendation.
Mr. Wilcox, you have a right of elocution, they call it. You can tell me anything you think I should know or you want me to hear before I impose any sentence. You don't have to say anything, but if you have anything to say, now's the time.
I don't have anything, Your Honor.
You're shaking your head in the negative. I'll take that as a no for an answer. Mr. Wilcox, it doesn't, as I look at these cases, it seems that you're just not getting it. You're just not understanding that no contact is and means no contact. And that doesn't seem to mean anything to you. I can explain the process to you, but I can't make you understand it. That's something you're going to have to do. All I can do is impose 364 days on 4 different counts and decide whether to suspend that or not. If I impose those, I have them run concurrent. And I'm not so sure, but what some jail time isn't necessary to make you understand that no contact means no contact. An order of protection until it's changed or is no longer in effect is just what it is. It doesn't seem to matter to you. But that's all I can do to enforce the order. I am going to suspend all the jail time on the condition that you have law-abiding behavior, specifically with regard to orders of protection. I guarantee you this, that if the matter comes back and it's proven that you have re-violated the order of protection, I will impose substantial jail time. That'll put you in a position of not being able to contact. There's a lot of attempts to violate no contact orders, but everything in and out of the jail, as you know, by telephone is recorded, and that's the best proof there is of a violation. I don't know what else I can tell you. I'm out of words. The city is taking no action, apparently, Mr. Redfield, with regard to docket number 7, compliance with the previous issue. Mr. Wilcox, I'm going to wish you the best of luck. We'll dismiss all the remaining counts. Yep. And that's many, many years. These are these remaining cases that are all being dismissed at this time. That the fact that you were charged with that many violations, that remains a fact and something that may be taken into consideration at any future hearing. I'm going to wish you The best of luck, Mr. Wilcox, and remind you that the keys to the jailhouse they're right there in your pocket. It's up to you whether you go back to jail or not. Somebody wishes you to violate an order of protection, that's just their wish. You're going to be the one that going to have to go to jail or be found in violation. So, all I can say is good luck. You take care.
Thank you, too, Your Honor.
Anything further, Mr. Haverco?
Nothing further on these matters, Judge. Thank you.
Nothing further from the city. Mr. Wilcox, that'll conclude the matter. Good luck to you.
Thank you, Your Honor.
Morning, Your Honor. This is Paul Scott. And that is number 4 on the arraignment calendar. It comes on the calendar for arraignment on a criminal trespass in the 2nd degree. And I've had an opportunity to discuss the case with Mr. Scott. And I've had an opportunity to discuss with him what an arraignment is as far as being read the charge in open court, the elements that the city would have to prove, and the maximums that could be imposed. With that understanding, he'd like to enter a straight plea to the charge. In doing so, he'd like to waive formal arraignment and proceed with a plea and sentencing hearing. I prepared a statement of defendant on plea of guilty that I've reviewed with Mr. Scott, and I believe he understands what's in that form, and I've reviewed with him the rights that he gives up by pleading guilty, namely right to trial, right to appeal, and so on, testify or not. So I think he's ready to proceed, and I would ask Your Honor to inquire.
Mr. Scott, good morning. For the record, your name is Paul Harvey Scott.
Correct.
You disagree with anything at all your attorney just said?
No. I have stuff to add. I mean, possibly, if I could.
Now, we've been down this path more times than I can care to remember. Mr. Scott,
Yes.
through the drill again.
Can I explain a little bit?
Pardon?
Can I explain a little bit?
Yeah, there'll be time for that. You certainly,
Okay.
certainly can.
Sure.
Your name's Paul Harvey Scott, and you're 37 years of age.
Yes.
I'm looking at the statement of defendant on plea of guilty to 1 count of criminal trespass, 2nd degree misdemeanor, the maximum penalty, 90 days in jail and or $1,000 fine. Have you gone over the plea process this time with your attorney?
Yes.
Accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal. I could impose up to 90 days in jail or up to $1,000 fine. You realize that?
Yes.
How do you plead to 1 count of criminal trespass, 2nd degree, alleged to have occurred within the city of Yelm on May 12, 2023, guilty or not guilty?
Guilty.
Make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty, except the recommendation is to sentence?
No.
I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea process. Now, you wanted to tell me something, Mr. Scott?
Yes. No, there wasn't a disgruntlement or anything. Nobody called on me, but I was going around the back of the building when one of my people that I know, Sean, one of my friends, they were looking for him. He was yelling up and down in the front, and the police that I didn't recognize the police that gave me I missed the court date and I didn't recognize them. However, the police that gave me the warning not to go in front from wall to wall in front of the Nisqually Plaza did say I could go around back. That's all. I don't know if you can enter an Alfred plea or if you guys have that, but that was another question I had. But I've already entered guilty, so that's all I wanted to say.
Mr. Scott, as I realize, how many times have we spoken?
Probably like 10.
I can't count that high. Has to be a time in your life when you didn't get arrested on a regular basis.
No, I know. For a long time.
That would have been a long time ago. There's got to be a way, maybe, of getting back to that time.
Yes, I don't see any reason why I would have any problem. There's plenty of places I could go where, I mean, I wouldn't be violating, and I can go around the road to go around back if I don't want to go down Front Street. I mean,
That'd be the best thing to do. And maybe the best thing to do probably would be to give up the substances you put in your body to that always seem to be there when you commit an offense. That's up to you. I'm not going to order you how to live your life. I can't. That's your choice.
Okay,
I'm gonna
yes,
ask you maybe to reflect on, where you've been, where you're going, and maybe try to get back to a time before you started getting arrested on a regular basis.
okay,
You can do, Mr. Scott, is wish you the best of luck and hope that the next time I see you, it's just passing you on the street and not on a computer screen from the Nisqually jail.
yeah, okay,
Good luck to you. You take care of yourself, and whether or not we meet again this way it's up to one person, not me, you.
okay, thank you.
Good luck to you.
What's that?
Good luck to you.
Oh, good, thank you, I appreciate it. You as well, but you don't probably
The
need it.
only one that can.
What's that?
Take care of yourself.
You too, thank you.
Do that.
Thank you, Your Honor. All right. So we ready today?
Might as well, just that's,
Okay, let's give it a go.
yes, sir.
Okay. Morning, Your Honor. This is Michael Ward. Matter comes on for a couple of matters, item numbers 5 and 6. Or the most relevant one this morning, item number 6, matter comes on for a pretrial hearing on a protection order violation. Mr. Ward and I have had some additional discussions about his case and kind of where he wants to go with it. And I believe at this time he has elected to, after reconsideration, proceed with entering a guilty plea to this charge. I've gone over it, the statement of defendant on plead guilty with him, the rights that he gives up. I think he understands the right he gives up when he pleads guilty, and I think he's ready to proceed today. Ask Your Honor to inquire.
Well, first, I'll turn to the city. I'm looking at the statement of defendant on plea of guilty. As I recall, at the last court date, Mr. Ward indicated that he would prefer to have the matter charged in county court as a felony rather than as a misdemeanor in this court. That apparently has changed. What the city's position?
The city also remembers Mr. Ward's statements.
Can't really hear, Your Honor.
I'm hard of hearing.
I can't hear either.
Apologies. The city also remembers that, and at this time, any hearing for the revocation, the city would ask to be set over. And I don't believe the city's willing to accept a guilty plea under this recommendation at this time.
You ever go? That's the city's position that they want the matter set over a couple of weeks to give. Is the county aware of this situation at all?
The county is aware.
And are they considering, or what's their position?
The county is considering charging the violations as a felony.
Mr. Havico, given that status, what I'm inclined to do is set the matter over 2 weeks and see what the county's preference is.
Well, I was hoping that the city was going to be amenable to the entry of a plea today. How much time have you done in custody so far?
I'm a little over 50 days, I believe. I'm not completely sure on that.
I guess one thing, I'd argue if the city is not prepared to proceed with the plea today and wants to set it over 2 weeks, I believe that Mr. Ward is now done he's been in custody around 50 days. I think he's actually done in balance the amount of time that Your Honor imposed on that other case. So I guess I would ask Your Honor then to consider amending the conditions of release in releasing Mr. Ward so he could appear out of custody in 2 weeks, since he would otherwise be done with his sentence, and were we to have proceeded with a plea today, while of course there's no guarantee what Your Honor would do, but it was my anticipation that there was a fairly good prospect of him being released today otherwise.
I am mindful of the fact that with bail set on Mr. Ward, we are under the 60-day rule on that. What I'm inclined to do, is, given the posture of the case, is simply to continue both matters for a shortest possible time. That would be 2 weeks.
Okay.
To see what the county wants to do. I will at least review significantly the conditions release with regard to bail at that time, 2 weeks hence. That'll conclude today's hearing. Matter will be recalled next available court date. And that would be June 22nd.
Thank you, Your Honor.
Thank you, Mr. Africo. Mr. Ward, thank you. That concludes. the hearing.
Can I go ahead and sign? Yeah. Okay.
That concludes the in custody calendar. I'm assuming that everybody's here is here for either a 9 o'clock hearing or a pretrial. We're going to take a brief recess. We're going to wait for Mr. Haverco to he'll be en route from the jail. He'll be here in a couple of minutes. We do have attorneys here. Let's deal with those. back on record for any attorney matters that, I understand we have some attorneys in the, Stephen Bacon. Okay, take that now. Good morning, Mr. Coker. You're muted. If you'd unmute yourself, we'll address your matter at this time.
Good morning, Your Honor. Can you hear me okay?
I certainly can. Can you hear me okay?
I can. Your Honor, I'm here on the Stephen Bacon matter. It's on the 9 o'clock docket. Mr. Bacon's present over my right shoulder. Your Honor, this is a case I discussed with Mr. Ratfield earlier this morning, and and in O courts is a proposed motion to dismiss without prejudice at this time. There is a rhyme and reason to this. We've got another matter up in Pierce County that occurred prior in time to the issue we're dealing with in in Yelm, so that we're going to deal with the issue in Pierce County. Then I fully expect the city of Yelm to bring this charge back after we deal with the Pierce County matter. So that's the basis for the request.
Trusting the competence of all attorneys involved, I have no problem dismissing the matter. Mr. Ratfield, anything to add? Mr. Bacon, the charge is being dismissed without prejudice, which means, of course, that the matter can be refiled at a later date. I'll sign the order at this time electronically, and we'll be sending your attorney a copy of today's order. Good luck to you. That concludes the hearing.
Thank you, Your Honor. Thank you, Mr. Ratfield. I'll be back in touch. Take care.
Thank you, Mr. Gover. Take care.
Bye-bye.
Back to the dash. And next would be. Good morning, Mr. Schroeder. We'll take your matters at this time. Brian Bissaw is the first one.
Good morning, Your Honor. Yes, sir.
Mr. Bissaw is in the courtroom. Mr. Bissaw, good morning. For the record, full name Brian Broy Bissaw.
Yes, sir.
Matter set for pre-trial today. I'll turn to your attorney for the status of the matter.
Yes, and good morning, Your Honor. For the record, Dennis Schroeder on behalf of Brian Bissaw, who is present in the courtroom out of custody. Your Honor, this matter comes on for pre-trial, and I'm happy to report that we are here to resolve this by way of a stipulated order of continuance. The court will see that the form has been filled out in O courts. I have gone over this with my clients. The only thing that we need to do is set a review hearing date. I have discussed with my client how an SOC works, the important constitutional rights that he's waiving, and the fact that this is a agreement between him and the city. He understands that what will happen if he is alleged to have violated this agreement, and if the court finds that there was in fact a violation, and that there would not be a trial, the court would just read the police reports and determine guilt or innocence based on that alone, and then what the maximum penalties are based on the law. So, Your Honor, I do believe he's entering into this knowingly, intelligently, and voluntarily. I'd ask the court to find the same.
Thank you. Mr. Ratfield, anything to add?
Nothing to add, Your Honor.
Mr. Bissaw, do you disagree with anything at all your attorney just said?
No, sir.
He's worked out an agreement under the terms of which the matter is just sort of hanging there for a period of 2 years on conditions. The most important, of course, is law-abiding behavior, no further violations.
Yes, sir.
In return for the agreement, you've given up your right to go to trial, have witnesses, all the trial rights you'd ordinarily have. If there's a violation and the city proves that, we're back to square one. We'll read the police reports. That would subject you to a finding of guilty, very likely, and up to 1 day short of a year in jail, and a conviction, which would eventually these things become a felony. And you don't want to even go there. What you're getting, though, if you abide by, is a complete dismissal. The charge just goes away. Any questions at all? I'll sign the order approving the agreement, and we're not going to set the matter for any future need to appear, any review matter. We'll simply review the file at the end of 2 years, and if you're in compliance, the charge will be dismissed. Mr. Schroeder, anything to add?
No, Your Honor. Thank you.
Signing off on the SOC, we'll be sending you copy of the document, and your client can get a copy of that before he leaves today.
Very good.
Mr. Schroeder, you can get a copy of the order by, or the SOC by going to the window outside the courtroom and to your left, and good luck to you. You take care of yourself.
Have a great day.
You as well. It'll take me just a minute to. I'm having that same problem with the, that window coming up, saying, oh, well, but it's okay now, I think. I got it, yeah, having trouble getting rid of it. So Schroeder will now call the matter of, Yelm versus Chris McGuire. It's Mr. McGuire in the court. Mr. McGuire, come on up and have a seat. Your attorney is present, by way of computer. I can see his face, but you can't, but we're going to address your matter at this time. Mr. Schroeder?
Thank you, Your Honor. Dennis Schroeder, on behalf of the defendant, Chris McGuire, who is present out of custody. This matter comes on for Mr. McGuire's arraignment, I believe. The defense acknowledges receipt of the charging documents. Stipulates a probable cause for today's hearing only, and ask the court to waive formal reading, ask the court to enter a plea of not guilty.
Mr. McGuire, we're just here, we're just going to address an arraignment. Citation alleges that on or about March 30th, 2023, you committed the offense of violating the order of protection that you were subject to. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in custody and or a $5,000 fine. Your attorney has entered a plea of not guilty on your behalf that preserves your rights pending a pretrial. Mr. Schroeder, do you prefer the pretrial to be set at any particular time?
I don't not sure when the court hears pretrials. Obviously, we haven't received discovery yet, so I will need some time for that.
June 22nd, July 6th, or July 20th?
July 20, please, Your Honor.
We'll go to July 20th. Mr. McGuire, we're setting the matter for July 20th. I'm not going to take you into custody. There's some judges that would, based on the history here. Conditions release are going to be law-abiding behavior, and that would include obeying specifically any order of protection that's entered. The violation of that condition may well result in a setting of bail. Any questions at all?
None.
We'll enter an order on today's hearing. You can get a copy of that. The other condition of release is stay in touch with your attorney who's appeared on your behalf and is representing you in this matter. Any questions at all?
Not this time, Your Honor.
That concludes the hearing. Mr. Schroeder, we'll be sending you a copy of today's order. You
Yeah,
take.
just for the record, I have gone over his rights and arraignment with him. I don't know if the court has availability for him to sign that document there in the court. But I did go over it with him.
Hey, thank you.
All right, thank you, Your Honor. Does that conclude the hearing?
That concludes the hearing. You can take care of yourself. Talk
Thank
to
you
you
as well.
July 20th.
See you then.
Again, Mr. McGuire, you get a copy of the order. It may take a minute to get that, but don't leave without it.
Thank you, Your Honor. Good morning, Your Honor. I'm here on Nicholas Ragers.
Good morning. We'll address that matter at this time.
And Your Honor, for the record, Austin Onsing on behalf of, oh, sorry, there we go.
Hey, I'm going through the, Mr. Ragers, I see you're you're muted. Could you unmute yourself? We're going to address your matter at this time.
Yeah, I'm good.
Hey, thank you. I can now see Mr. Rager's. Mr. Ansett, I'll defer to you for the status of the matter.
And Your Honor, for the record, Austin Onsing, I'm standing in for Attorney of Record Dougal Narlick. This is a defense motion to continue for further negotiation and investigation. Mr. Narlick did upload a motion into O courts using the new commencement or the new pretrial date of July 6, 2023 at 9 a.m.
Any objection at all? I'm signing the order electronically clicking on the order as we speak. I will be sending both you and your client an order resetting the matter to July 6th. Mr. Agers, the conditions release remain in effect, and that includes staying in touch with your attorney and reappearing on July 6th. Any questions at all?
Understood. Thank you.
Granted, any questions?
Nothing further from defense, Your Honor. I appreciate it. Thank you.
Thanks for hearing. You take care. Have a good day, the both of
You
you.
as well.
You too.
And that's it for right now. So we're missing a Joe Cutter. The Bolton. With regard to docket number 7, Mr. Woody has called in. He is ill. We're going to reset the matter with notice to be sent to Mr. Woody and his and Mr. Victory. Mr. Victory, your attorney has called in. We can't hear your matter today. He's ill. We're going to have to reset the matter.
I'd like, that's fine. Can I represent myself then? Because I really need to. I'd really like to just let you know what's going on and speak for myself, please. That will help.
I'm not allowed to do that. Now, you are allowed to represent yourself, but Mr. Woody has to withdraw before I can address you personally. It would be improper for me to address your matter with him.
He hasn't reached out to me at all via phone, via email since I've asked him. I hired him to help me with it. And I've been asking him questions like if I need pictures of the intersection that I am in question, because it was a rolling
Well,
stop.
Mr. Victor, it'd be improper for me to hear anything about the matter. If there's any way that I could do that, I realize these things happen, frustrations with it, but yeah, I simply can't do anything today except reset the matter, and I will June 22nd. That's the only thing the law allows me to do.
Is that okay? Thank you, Your Honor.
And I want you to get a copy of today's order at the window outside the courtroom to your left. And
Okay.
good luck to you. You take care of yourself, and hopefully your matter can be resolved with Mr. Woody.
Thank
Good
you
luck.
for your time.
Mr. Pender. Give him a minute to catch up here. Sorry, I forgot the last. I'll wait for Mr. Williams. We have people in the courtroom. I'm not sure. Are you here for a 9:45 hearing or for a 10 o'clock pretrial? And who was here first? Sir, come on up. If you were here for a 9:45 hearing, tell me who you are. Michael Perry, Carol.
Yeah.
So Carol, good morning. A warrant was issued for your arrest for due to failure to appear, but you're here for an arraignment. Yeah. Let's find out who else is here. Zachary Conrad. You didn't appear for a pretrial. Your attorney was no doubt Dan Haverco. He's in the building. He'll be out here in a minute. Mr. Haverco, good morning. Before the court is Michael Perry Carroll. He's docket number 3 on page 9.
Okay, got to see it.
Here for an arraignment today.
Okay.
Mr. Carroll, the citation I have alleges in honor about February 9th, 2021. Committed the offense of theft in the 3rd degree, which is a gross misdemeanor. The maximum penalty and conviction would be 364 days in jail and or a $5,000 fine. You're entitled to a lawyer to represent you in the matter at the public expense if you're indigent. Are you asking for a court appointed lawyer?
Yes, sir.
I will appoint Mr. Haverco, who's next to you there, to enter a plea on your behalf and to represent you.
Thank you, Your Honor. Would stipulate to probable cause and ask the court to enter a not guilty plea.
Mr. Carroll, plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial. That'll give you a chance to talk to Mr. Haverco. What I want you to do is exchange contact information.
We'll be talking. Okay.
Mr. Carroll, setting the matter to July 6th, that's 2 weeks from today. You've got contact information via exchange. I'm entering an order on today's hearing. All the conditions of release are stay in touch with Mr. Haverco and law-abiding behavior. Get a copy of today's order by going to the window outside the courtroom and to your left. And then we'll see you back here on July 6th.
Yes, sir.
Any questions?
Yes, sir.
Thank you for appearing. Good luck.
Great, thanks.
Very finally. Mr. Haverco disappeared again. I don't think on this one. Mr. Pennington, come on up. Your attorney stepped out of the courtroom, but what we're simply going to do is we'll quash the warrant and reset the matter for another pretrial. Would July 6th work?
Yeah.
Great. I want to thank you for appearing.
Yeah, I just, I tried quashing it when I was in Department of Corrections, but they said that my release date was too far out. And so I was just trying to take care of what I need to take care of now.
One thing at a time. How is life going?
That's going good.
Yeah, people do. They send me a kite from the jail saying, do it, but I really can't do anything until you are passed. Especially if you get your release date is how it was. He's still on DOC?
Yeah.
For a while. Everything going okay there? Hopefully, yeah, take care of yourself. I hope you're doing well. You seem like it. Hey, you showed up, you're taking care of things, and that always makes the probation folks real happy.
Absolutely.
Pretrial July 6th. Mr. Haverco evidently had something to say, something to do. I'm signing the order on today's hearing. Warrant will be quashed.
Just write down the phone number here and I'll give it to your attorney. And then his contact should be on.
Pennington, good to see you. Thank you. Here in person and not hear from you behind the gates of the penitentiary. Absolutely. That's hopefully, that's something that's in your past and will stay there. Thank you, Your Honor. Good luck to you. Thank you. See you in July 6th. See you. Thank you for appearing. Thank you.
Grab a moment to step away.
Absolutely. Morning.
Good morning, Your Honor.
Back on record, we'll address your matter at this time.
And then, good morning, Your Honor. For the record, Joseph Carter on behalf of Mr. Poland, who's present to my right. I do apologize to the court for for the court's indulgence.
No problem, no problem. We weren't going anywhere anyway. Mr. Bowen, good morning to you.
Good
Full
morning.
name Adrian James. Bowen.
Yes, that's
Good morning.
Good morning.
And, good morning again, Your Honor. For the record, Joseph Carter on behalf of Mr. Poland. This matter is currently on for a pre-trial, Your Honor. I do anticipate that we do have a proposed resolution in this matter as well, Your Honor. Thank you.
I am looking at statement of defendant on plea of guilty, it looks like, to an amended charge of negligent driving in the first degree.
That is correct, Your Honor, and I can go over the colloquy if you prefer, or defer to the court.
Pardon?
I can go over what I went over with Mr.
No,
Bowman.
I'll go.
Thank you.
Again, for the record, your name, Adrian James Bowen.
Yes, sir.
I'm looking at the statement of defendant on plea of guilty to one count of negligent driving in the first degree, amended down from a original charge of DUI. Plea form tells me you're 42 years of age, you've been through 12 years of school.
I didn't hear that. Sorry.
Any issues at all, reading, understanding, going over the plea process? And if you had any questions about what it meant to enter a plea of guilty, were your questions answered?
Yes.
Negligent driving in the first degree is a misdemeanor. The maximum penalty on conviction would be 90 days in jail and or $1,000 fine, which I'd be free to impose regardless of what's recommended. You realize that?
Yes.
And if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing from which there would be no appeal.
Yes.
With that in mind, it's to one count of negligent driving, first degree, alleged to have occurred within the city of Yelm on January 30th, 2023. How do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make the plea guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea. The recommended sentence is all jail time suspended on the condition you have law-abiding behavior, especially when it comes to alcohol related offenses. And I'm sure there's a fine here someplace, which I'm not finding.
Your Honor, and can I address that? It is an agreed recommendation. However, Mr. Bowman does have some financial types of issues.
Oh, okay, that's a recommended no fine.
No, Your Honor, I mean, I didn't, my apologies to the city. We did not discuss that. We did agree to a fine. However, there is some, once I got here this morning, started speaking with them, they are under some kind of financial restraints. They both do still have, they have 2 kids, 2 children, Your Honor. They both do have part-time jobs. They do own their own home. However, at this point, it's financial arrangement. They do have, as Ms. Bowman did say, good intentions, would like to pay off everything, put themselves back in the position they were before this incident, Your Honor. However, they just need time to do that. And any break in with the cost would help out Mr. Bowman and his wife very much. Thank you.
Mr. Redfield, anything to add with regard to any fine?
No, Your Honor, the city would be happy to and
And we would request any that the court could waive, Your Honor. They would. Thank you.
Mr. Bowman, you have a right of elocution. You can tell me anything you want. You don't have to say anything. But if you have anything you want me to know, now's the time.
Yeah, it's just a really bad day, and I made some bad choices, and we're fixing that.
Problem with real bad days is sometimes they just go to hell altogether. And that's your attorney has heard it. I'm sure anybody that's involved in criminal law has heard of the bad day that ended with a trip to the hospital, a trip for somebody else to the morgue, et cetera, et cetera, et cetera. Your attorney's done just a great job in getting the charge reduced from a clobbering DUI conviction I've said many times that a DUI conviction is worse in terms of impact on your life than an awful lot of felony convictions. Neg one is a reduction. It'll count as a prior if you get rearrested, but please learn to live life so you don't impose the bad day that you're having on anybody else. Your attorney, I know, is very familiar with the cases involving the tragedy and the loss of life. You've got the victim's family that has to live with that for the rest of their lives. A perfectly nice individual who made the mistake, having to live with the guilt of having done a horrible thing that they would have never done if they were. So I'm going to follow the recommendation as to a sentence with regard to jail time, 90 days, all suspended on the condition you have law-abiding behavior. That includes no driving unless licensed and insured. And I think under the financial circumstances, the money is the least important thing here. The most important thing to me is that you learn from the situation. Be human. Go on to make new mistakes. Don't repeat old ones. Okay, get this behind you. Learn from it, and move on with life. I'll sign the judgment and sentence. I'm just simply not going to impose any fine in this matter.
I appreciate it.
You can be pushing those in Charlotte. This one appreciates that very much.
I'll be signing the.
And then we do have a copy of the judgment sentence up here. I remember we can sign that as well.
Great. Reviewing the judgment and sentence. Draft field, if you and Mr. Cutter could sign off on the JNS.
Your Honor, I did have a chance to review it, and then if that does comport with the rulings.
Great. Lord, yeah, financial circumstances are the cause of great stress in anybody's life. Just work through that and get that behind you and move on with life. Any questions at all?
No, thank you.
All I can do is wish you the good luck.
Thank you very
Take
much.
care of yourself. Your attorneys put you in just a tremendously successful position here, but it's up to you to take advantage of it. Good luck to you.
Thank you. Appreciate it.
Get a copy of today's paperwork by going to the window outside the courtroom and to your left. Mr. Cutter, good to see you. You take care of yourself.
You as well, Your Honor. Always a pleasure. Thank you for pushing the
Thank you.
buttons again.
Thank you. Not sure I deserve that, but thank you.
You do, Your Honor.
I'll try and get a labor dismissal. But no. Whatever that was. Whatever you did, it worked. It now allows me to end. Sign.
Just come on, pass it. This is Mr. Dury. Matter comes on for a pretrial hearing on the 10 o'clock calendar. And
Good morning, sir. How do you pronounce your last name? Dury. Mr. Dury? Let's see. I have to ask because if there's a way to mispronounce a name, I'll find it.
Everyone always does.
The matter is set for pretrial. I'm looking at the motion to continue the matter. How far would you like to go, Mr. Hamilton?
well, where he's at is he's right on the cusp of getting reinstated. He's dealing with DOL. He got them, they won't accept your chemical dependency evaluation directly from yourself. They have to, they have to receive it from the treatment place, and they sent it, and then DOL saying they don't have it. And so it's kind of where we're at. And so it sounds like if we can kind of get the right paperwork in the right places, he may be able to reinstate here. So I'd ask to reset it like 8 weeks. Hopefully that's enough time to, you know.
Mr. Dury, as we all, the attorneys know, dealing with the Department of Licensing is not any picnic. You make 10 phone calls to them, ask them 10 questions, the same question, that you're gonna get 10 answers. So will we set the matter out? How far about, you want to go about 8 weeks?
Yeah, I mean, hopefully that's enough to. Sounds like there's just a lot of follow-up he's got to do to make sure they have the paperwork, and I guess his first eval said that he didn't need treatment, and DOL, they did get that eval, and they said, well, they don't agree with that.
August 17th.
They just, they don't like it. So he had to start classes somewhere, so he's doing classes now.
It's good that an administration.
Yeah.
Administrative agency knows more about the syndrome than the experts in the field. August 17th?
Sure.
Let's go with August 17th. Mr. Dury, I'm gonna wish you the best of luck with that. And yeah, again, try not to get too frustrated in dealing with the Department of Licensing. That's a brick wall that I can run up against many times. Signing an order, resetting the matter to August 17th. Again, conditions released, law-abiding behavior, don't drive unless licensed and insured. Appear for court on August 10th. You can, of course, stay in touch with your attorney. Any questions at all? Sure. Good luck to you. Again, get a copy. Go into the window outside the courtroom and to your left. Take care.
Thank you.
Luck. You can next call on the 9:45 calendar, Deanna Brass. Ms. Brass.
Ms. Brass, good morning. How are you?
Right here. That it comes on for, the warrant quash calendar, so
Yes.
we would ask concurrently that the warrant, she's here, would ask that the warrant be quashed, and the matter was otherwise on for pretrial. She and I have previously discussed this case. So we'd like to proceed also with entering a plea today to the amended charge of criminal trespass in the second degree. And the city and would be asking for the $250 probation fee. She is maybe not completely homeless, but off and on homeless, definitely a financial struggle. So I'd ask the court to waive any costs or fees.
Good morning, ma'am. For the record, is your name Deanna Lee Brass?
Yes.
If I mispronounce your name, please correct me.
No, that's correct.
I'm looking at the statement of defendant on plea of guilty to one amended count of criminal trespass second degree, which is a simple misdemeanor. Maximum penalty would be 90 days in jail and or $1,000 fine. I'd be free to impose that if I accept the plea, regardless of what's recommended. You realize that? Plea form tells me you're 35 years of age. Any problem at all understanding the plea process? gone over the process with your attorney? Realize if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. That in mind is to one count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on December 11th, 2022. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead? I will find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy factual elements of the offense. Recommended sentence, I've heard. Anything you'd like to tell me?
I was there trying to get some food is all for the family. And I know I shouldn't have been there, but I didn't have a way to get to any other store at the time. I was on the bike, so. I know I shouldn't have been there and I haven't returned since and don't plan to return.
Ms. Brass, these orders, they're sometimes it's not the models of clarity, but yeah, your attorney indicated you're dealing with a housing situation at the time. I'm going to wish you the best of luck with that. Mr. Redfield, anything to add to the? I'm going to follow the recommendation, 90 days in jail, all suspended on the condition you have law-abiding behavior. And I think given your economic circumstances, I'm not inclined to oppose any fine. I'd rather have you devote your resources to getting stable housing. And all I can do is wish you the best of luck with that. That's it. And of course, it's always a good idea, stay out of the attention of law enforcement in the meanwhile. That these interruptions of having to go to court doesn't really help matters a lot. But Ms. Brass, you have been here for quite a while. I want to thank you for your patience. Wish you the best of luck. Take care of yourself. Ms. Brass, that concludes the hearing. What I want you to do is get a copy of today's paperwork by going to the window. And I'll wish you good luck. Any questions at all?
No, thank you, thank you.
You take care of
Thank
yourself.
you.
Thank you.
Next matter would be on the 10 o'clock, Christopher McGuire. Have a motion to continue.
This is Mr. McGuire.
Yes, Your Honor. There's a motion to continue in Oak Courts. It's got 3 different matters, as I recall, and trying to sort out, how those are all gonna be handled. So we're at this point kind of trying to tag this case along with his other matters.
Mr. McGuire, that's how things are. When you have courts here and there, sometimes it's a matter of getting them all put together. About how far out would you like to go?
Oh, with the other guy? Yeah. The other, I guess his next hearing in this court with his other counsel on his other case is sometime in July, so.
July 20th.
So would it make sense to set at the same time so he doesn't have to come back to court? On a separate?
It does. Oh, we can set it, maybe not at the same time, but on the same
Right,
day.
right.
So the same date. Yeah, let's go the same date, but the 10 o'clock.
Okay.
We're resetting it to July 20th, 2023. And now, again, already heard me say this, I think, protection order means no contact. That's it. And even if it's invited, no contact means no contact until a judge amends it or changes the order. We're setting that your first hearing will be at 9 o'clock, and your second hearing will be at 10 o'clock. And perhaps the attorneys are going to be in contact. All that concludes the hearing, so get a copy of the order at the window, and we'll see you back here in July. Take care.
Good day.
Let's double check. You know what calendar you were on? What time? Oh, there's a 9:45 matter that we could take up, Your Honor.
Sure.
Come on.
And your name, sir?
I think he said Anderson.
Yeah. Dustin Michael Anderson? Yes. Mr. Anderson, you're here for an arraignment. You missed an earlier arraignment, so you went to warrant status. The citation alleges that on or about October 11th of 2021, you committed the offense of violating the conditions of a no contact order of protection. That's a gross misdemeanor. Conviction would bear the possibility of 364 days in jail and or a $5,000 fine. You have a right to have a lawyer represent you at public expense if you're indigent. Are you asking for a court appointed attorney?
Yes, sir.
I'll appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time. Mr. Haverco?
Thank you, Your Honor. Would stipulate to probable cause as the court to enter a not guilty plea.
Mr. Anderson, a plea of not guilty has been entered. Now it's important you make your court date, so let's stay on a warrant status.
Sure, you have to do that.
Yeah.
And then.
July 6th, 10 o'clock, your pretrial.
Right here. Okay. And we'll talk later.
Citing today's order, and Mr. Anderson, if you would get a copy of today's order at the window. I do want to thank you for appearing. Better late than never. So you saved yourself a trip to jail by just coming into court voluntarily. Good luck to you. Take care. We'll see you on July 6th. Thank you. Trevor, go. We're going to be, you need a moment to discuss cases. We'll be at recess for a moment. That's it. Ready to go on?
We're just kind of working through my
Okay.
folks there,
Uh,
but ready on some stuff.
okay, go ahead.
Oh,
We're
thank
back
you.
on record. Mr. Abercrombie, I'll defer to you for the order. in which the
Thanks,
cases
Judge.
are called.
So this is Mr. Swarce. It's number 10 on the 10 o'clock calendar. Matter comes before the court for a pretrial hearing on a hit and run unattended, and then a negligent driving first degree. I think we've reached an agreement. He's going to enter a straight plea to the hit and run. Upon the court's acceptance of the plea, city will move to dismiss the neg driving.
Good afternoon, sir. For the record, I hope I'm not pronouncing your name, James Patrick Sorsey? Swats. As again, there's a way to mispronounce a name. I'll find it. I'm looking at the statement of defendant on plea of guilty to one count of hit and run unattended. Plea form tells me you're 55 years of age. Have you gone over the plea form and the process with your attorney? And if you had any questions about what it meant to enter a plea of guilty to a criminal charge, was your question answered? Answered them all. If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which could be up to 90 days in jail and or a $1,000 fine. In as much as this is a misdemeanor, you realize that? I do. That in mind, is to one count of hit and run unattended, alleged to have occurred within the city of Yelm on April 27th, 2023. How do you plead, guilty or not guilty? Guilty. To make that plea of your own free will. I do. Anybody make any threats or promises to you to make you plead guilty? Negative. Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Recommended sentence is 90 days all suspended, $250 probation fee, suspension on the condition you have law-abiding behavior. City, have anything to add?
That would get, what's the word?
Trevor, anything to add?
Oh, nothing to add, Your Honor. He had a question about bail, and I was going to tell him that, bail is typically exonerated, and the case is terminated.
It is.
Yeah.
And they give the money back? Where do I? Well, it depends. If it's money, if you hired a bail bondsman, that, no bail. If it's cash bail. If it was cash bail and you posted it yourself, yes, exoneration, you'll get it. It is exonerated. You will get it back. No, is anything you'd like to tell me about the offense? No. Any other questions about the bail? That's no. As to what count of a hit and run attendant, that's how do you plead guilty or not guilty? Anybody make any threats or promises to you to make you plead guilty? Your statement in paragraph 11 does satisfy the factual elements. I know the recommendation. We backtrack a little bit there. Anything you'd like to say about the recommendation? No, sir. I'll follow it. 90 days all suspended on the condition you have law-abiding behavior. And there's a dismissal of the neg 1 charge that goes along with it. That is probably the more serious charge of the two, I'm thinking possibly. It's a good idea in my opinion, to completely separate drinking from driving. Nothing good happens, and I've had to deal with countless tragedies over the years that have resulted from drinking and driving. No winners there, none at all. We'll accept the plea. We'll sign a judgment and sentence to that effect. Everything is on a computer screen these days. It takes a minute to plow through the process. Being a cyber dinosaur doesn't help me much anyway. That concludes the matter. Get a copy of today's paperwork by going to the window outside the courtroom to your left And you might ask about the bail is automatically exonerated, but you might ask as to how long it's gonna take or that can happen today, but it'll take a day or two.
Also,
Or more. Mr. Rupp, good luck. You take care. Thank you for appearing.
Next matter would be Thomas Jones
Thomas Jones,
on the 10 o'clock. Matter comes on for the motion, and I think the city was asking for more time. I think the city was moving for continuance.
Is city's requesting this to be reset.
any response?
No objection.
Mr. Jones, thank you for
I
appearing.
guess Mr. Jones.
Well, how much time does the city need?
See. 4 weeks.
July 20th work?
What's that? I'd have to take a look.
July 20 work?
That's fine. I'll take a look.
Thank you.
Yeah. No, I'll take a look. I can't tell you. Yeah, yeah. You'll get a copy of the order. Yeah.
That I'm signing as electronically, of course, as we speak. Mr. Jones, you can get a copy of that by going to the window outside the courtroom to your left. Good luck to you. Take care. Thank you for appearing, and we'll see you July 20th.
Thank you. 20th or 24th?
July 20th, 20. And that'll be in the order.
Thank you. Have a good day.
James Bittner.
Excuse me.
Mr. Bittner is on the 11 o'clock.
Mr. Bitter, good morning.
Good morning, sir.
Let's see. Bitter, I'm looking at a motion to reset the matter.
Right, I'm just gonna have him sign. We haven't had, go ahead. His number wasn't working, and so I wasn't able to talk to him ahead of time, so it's one of these police reports, it's a real back and forth, and we just need more time to
How
discuss
far
the
would you
case.
like to go?
Yeah, is there anything in your schedule that's an issue, or? I'd reset at least like 4 weeks. We have a waiver in the.
That sounds like July 20th.
Sure. July 20th.
Mr. Bittner,
896.
resetting the matter to July 20th. Make sure you're in communication with Mr. Haverco in the meantime. Any questions at all? Any conditions released earlier set remain in effect? Standing the order of reset. Mr. Bitter, you can get a copy of today's order by going to the window. And we'll see you back here on July 20th. Any questions?
No, sir.
Good luck.
Hey, thank you. Have a great day.
And you as well.
Next matter around the 11 o'clock would be Kirsten Jones.
Mr. Jones. Good morning.
Good morning.
So a matter comes before the court on a DUI. And we're presenting a stipulated order of continuance with a later reduction to negligent driving first degree. She does have an evaluation, has been completed with Freedom Recovery. And it wasn't a significant plan that was recommended, but just a little bit of one. So there's some things she's got to do, but she's been doing everything she has to do to take care of this.
Stratfield City have anything? No. And for the record, you're Kristen Marie Jones.
Yes.
I'm looking at the SOC stipulated order of continuance. It's a contract basically between you and the city negotiated by Mr. Haverco, under the terms of which 24 months from now, if you comply with the conditions in the agreement, charges will go down to a negligent first degree conviction instead of a DUI. Now, the conditions are kind of significant here. Law-abiding behavior, most important. The drug and alcohol evaluation, compliance with any recommendation is part of it. We'll need that within the next 120 days per the agreement. Sometimes that can not be done, but let us know.
Want me to go grab that?
Significant court costs in the amount of $990.50. Now, we'll put you on a $50 a month payment program if that works. Now, in return for the agreement to get the reduction, you've given up your rights to go to trial, no appeal. If the city proves that you violated the agreement, we'll simply resort to the police reports, and that would most certainly result in a conviction for DUI. Now, a DUI conviction is worse in terms of impact on your life than a lot of felony convictions as well. So you've got quite a bit on the line here. Perfect.
With Ms. Jones' permission, handing the court a copy of her evaluation.
It's always good to see somebody be proactive enough to get this taken care of previous to the court order. Good. Level 1 outpatient DUI victim impact panel. Have you done that yet? Or
I have it scheduled for the 13th or something of July.
perfect. That's just make sure we get a copy of proof of completion of that.
Do you generally provide that to the court, or do I bring it in?
They sometimes do, but I would make sure that it coordinate with Mr. Haverco on that. I would make sure
Okay.
that it gets here. Yeah, you're the one that's in trouble if it doesn't get here,
Right.
not them. So,
Right,
so it's pretty much up to you
multiple copies, got it.
to see to that. Ms. Jones, I'm going to wish you the best of luck here. Hopefully 24 months from now, we can simply review the file and amend the charge to a much less serious charge and close the case. I'm hoping you've learned from this. The tragedies that occur when you mix drinking and driving are incredible. That's no winners there, no winners at all. Don't want to take the chance of going there. So hopefully this has been a very kind of a life-changing
It was a wake-up call, sure.
wake-up call, which we all need from time to time. I'm going to wish you the best of luck. If there's any issue making the fine payments, let us know. The money is the least important thing. The most important thing is that you've learned from the experience and it won't be repeated. I'm going to sign off on the agreement. You can get a copy of it. It's kind of a lengthy thing, so what I want you to do is read it over at your leisure, and then if you have any questions, give Mr. Haverco a call. If necessary, we can always schedule another hearing for clarification. But good luck to you.
Great, thank you so much.
Any questions at all?
No, thank
You
you.
take care of yourself.
Thank you.
Done.
Next matter would be Simon Raleigh, also on
Raleigh?
the 11 o'clock.
Good afternoon, sir. For the record, is your name Simon Matthew Rowley?
Yes.
Did I pronounce that right?
Yes.
I'll defer to Mr. Everco.
Thank you, Judge. So a matter comes on before the court, pretrial hearing, on a DUI and, Bill stopped to give information. And then there's some tickets and we have a proposed resolution. It's gonna enter an Alfred plea, to count one, DUI. And I did review with him, by the way, what an Alfred plea is. He just doesn't fully agree with what the evidence says. But he understands what the evidence would appear to be, or as it would appear to be presented to a jury or a judge sitting without a jury. He also wants to take advantage of the city's plea offer to dismiss counts 2 and 3 and the infractions. And the recommendation is that of the mandatory minimum.
And just,
It's treated as a no test, if I didn't say that expressly. It's to treat it as a no test DUI with the no test.
also
penalties.
a dismissal of the obstructing. charge as
Yes.
well.
Yes.
Good afternoon, sir. That's Mr. Alley. The plea form tells me you're 19 years of age and the plea would be to one count of no test DUI. Have you gone over the plea process with Mr. Everco?
Yes.
And if you had any question about what it meant to enter a plea of guilty to this offense, was your question answered?
Yes.
Now, if I accept the plea, you give up the rights contained in paragraph 5, there's no trial, no appeal. It's I'll simply impose a sentence, and that could be up to 364 days incarceration, since DUI is what they call a gross misdemeanor. You realize?
Yes.
With that in mind, as to one count of driving while under the influence of intoxicants alleged to have occurred within the city of Yelm on April 23rd, 2023, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty? Now, paragraph 11 indicates that you're making this plea in pursuant to the provisions of state versus Alfred. That an Alfred plea means, I'm not admitting that I actually did anything wrong, but I want to plead guilty to, as offered, to take care of the situation. And I concede that if the matter were to go to a trier of fact, the jury or a judge, the ruling could be adverse. There's enough room there for things to not go well. Is that correct? And I do find, based on the officers' reports, that there is a basis for the conviction here. The recommended sentence is for the standard first time offense. Is there anything you'd like to tell me about the situation? Anything you think I should know?
No.
Mr. Elliott, it was, as it turns out, the situation did result in the issuance of a lot of different citations, and that's usually an indication to the court that the stop and the process did not go smoothly for whatever reason. The consumption of, and you just heard me say that the consumption of alcohol and driving are just two activities that cannot go well together. If you've been drinking, not a good idea to get behind the wheel. Even if you're not intoxicated, if you get hit by somebody else, the first thing an officer is going to notice is, this person has been drinking, and that always changes the dynamic radically. And it's just best to just not go there at all. I'm going to follow the recommendation that this is the first one. The 364 days in jail,
He
all
did-
but 1 day.
Oh, I'm sorry, Jay, I don't mean to interrupt. He did, and I'm not sure if there's a way to verify it. He did think he may have spent more than 24 hours.
He did.
He
He
did,
did.
okay.
Oh, yeah, that's credit for
oh,
time.
oh.
Yeah, I'm required this sentence you to 1 day in jail. I'm giving you credit for time served on that. The remaining 363 days is suspended for a period. There's 5 years jurisdiction under a DUI. on the condition that you have law-abiding behavior, and that especially pertains to drinking and driving. The offense is $990.50, and they will be a fine. Now, where that 50 cents comes from, I had no idea. As a result of the plea, the Department of Licensing will take action against your license in a manner determined by your history. So Simon, Mr. Rowley, I'm hoping you're taking the matter seriously, and there's a learning element to the experience. The tragedy that comes from the deaths that are resolved, and there's thousands of them every year from drinking and driving, or I've seen too many of them, way too many. I'm going to wish you the best of luck. Take care. Hopefully in time, this situation will get behind you. It will drop off your record, given enough time. But again, an experience, this is one you don't want to repeat at all. I'm going to wish you the best of luck. Get a copy of today's paperwork at the counter outside the court.
Thank you. Thank you.
Mr. Elliott, thank you.
Oh, yeah, you'll get a copy from the clerk. Yeah, just take a lap and go to the window. She'll print it everything for you.
Hold on.
Oh, sorry. So the next matter would be Maxine Jocelyn. It's on the 10 o'clock calendar, number 5. Matter comes before the court on a pretrial hearing for theft and a criminal trespass. We have prepared a statement of defendant pleading guilty to the count 1 theft. Upon the court's acceptance of the plea, the city would then move to dismiss count 2. 12 months, law-abiding behavior, $250 probation fee.
Good afternoon, ma'am. For the record, is your full name Maxine Francis Jocelyn?
Yes.
Plea form I'm looking at is to 1 count of theft in the 3rd degree with a dismissal of a criminal trespass. Plea form tells me you're 37 years of age. Any issues at all reading, understanding, going over the plea process with your attorney? Any questions you might have had about what it meant? Were they answered?
No.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to 364 days in jail and or a $5,000 fine, regardless of what's recommended. You realize that. With that in mind, as to 1 count of theft alleged to have occurred within the city of Yelm on July 27, 2021, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, I do.
Anybody make any threats or promises to you to make you plead guilty?
No, Your Honor.
I will find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. Recommended sentence is all jail time suspended, And I believe I heard a $150.
$250, just the standard, yeah,
$250
standard probation fee judge.
Probation fee. Mr. Redfield, anything to add? Johnson, you have a right to tell me anything you wish, anything you think I should know before I impose sentence. You don't have to say anything, but if you have anything you want me to know, now's the time.
No, Your Honor.
You know, the only thing I'm gonna say is, stores aren't really hurt by this, except when, I've heard in the news recently, a Walmart up north somewhere closed because they couldn't keep up with the leakage, the theft that was, and it affected the community, they no longer have a place to go to buy whatever they need. And it also put like 150 people out of a job that they lost work because of that. What happens if they can keep up with the leakage? They know how much they're going to leak over the course of a year, and they adjust their prices accordingly. So who's being penalized is everybody that shops there, not just yourself. I'm following the recommendation, 364 days, all suspended. $250 fine. The jail time is suspended on the condition of law by the behavior. Stay out of trouble. That's it. Also, there's a dismissal of the criminal trespass charge as well. Ms. Joslin, any question at all?
No, Your Honor.
All I can do is wish you the best of luck and hope that this has been a learning. It's not too unpleasant, but a learning experience. Good luck to you.
Thank you.
And again, please get a copy of today's paperwork at the window. Review it carefully at your leisure later. And if you have any questions, give Mr. Everco a call.
Oh, yeah. I'll just talk to the clerk about it. Yeah. Let's see. Tyler Lunch. So I called you on the 5th, 688-9888, that's the number I have for you. And I left a message. So let's reset this so you and I have talked, because there's a lot of consequences. So let me prepare a document for that. This is Mr. Sorensen. I'm gonna.
Tanisha.
Oh, I'm sorry.
Still clicking on things here. Done. Go ahead.
Gonna fill out a quick motion to continue here. He and I haven't had a chance to discuss the matter yet.
Good morning, sir. Tyler Sorensen is your full name? About how far out would you like to go?
Probably at least, 4 weeks or more.
July 20th
Sure.
or more? Mr. Sorensen, we're gonna set your matter out. The resolution of any criminal matter, quite a bit at stake, requires a lot of consideration. Mitigation hearing that goes along with that, we'll calendar that right along.
Right. So that number is a good number. Okay. Okay.
Sorensen, July 20th, 11 o'clock in the morning. Any questions at all? No, any conditions released earlier said remain in effect. Mr. Sorensen, I want to thank you for appearing. We'll see you back here July 20th. Stay in touch with Mr. Haverhill. Have a good day.
Mr. Franzak? This is Gage Franzak. It's number 4 on the 11 o'clock calendar.
Gage Michael Franzak. Is it right? Good morning.
He's signing an SOC that we're gonna present here. I think the parties have reached an agreement that being a 12-month stipulated order of continuance, law-abiding behavior, $250 probation fee, then dismissal.
Franzak, I'm looking at a stipulated order of continuance. It's a contract is what it is. An agreement under the terms of which this charge will go away if you do certain things and not do certain other things. In return for the agreement, you're giving up the rights to you ordinarily have to go to trial, appeal if you things go against you, and cross-examine any witnesses that might be called. Conditions are stay out of trouble. First, last, and most important. There's a $250 probation fee that goes along with that. Set your payments at $25 a month. If there's a problem making the payments, let us know. That can certainly be dealt with. The most important thing I want you to do is take advantage of the agreement, get the thing dismissed, and that means stay out of trouble. Yeah, but it's up to you, Mr. Franzak. Signing off on the agreement. What I want you to do is go to the window, get a copy of the agreement, read it over carefully at your leisure, and let Mr. Haverhill know if there's any you have any issues, any questions about it. All right. Good luck to you.
Have a good day.
And you as well.
Next matter will be Charles Terrence. And I checked his driving record. He's still suspended, but he's suspended third, not suspended second any longer. So based on the information, I believe the city has a motion on the pretrial.
Have an empty cup. My little friend is back. That's okay. Wildlife is taking over the courtroom. I apologize for the interruption.
Oh,
cool.
Your Honor, this is number 12 on the 11 o'clock calendar. City's moving to reduce de novo on the second degree.
Let me back up. This is.
oh, Judge, this is Charles Terrence. It's number 11 and 12, 11 being a compliance diversion issue, 12 being a pretrial hearing on a suspended driving second degree charge. He's still suspended. His suspension status now is third degree. So on that basis, the city's moving to amend to an infraction.
Well, Mr. Terrence, that certainly makes it fairly easy. You don't plead guilty or not guilty to an infraction. You admit it or deny it. If you admit that you were driving without a license on your person, I'll impose a fine, no jail time, suspended or otherwise, and that'll close the matter. And I take it there's probably no action being taken on the docket number 11.
No action being taken.
Mr. Terrence, do you admit or deny? And the city's recommended fine, 150, 250. Mr. Terrence has set the fine at $150. It's pretty easy to lose your license, and there's a lot of things that can happen to you. And it's awful lot harder to get it back sometimes. What I want you to do is, yeah, now that you have it, make sure you keep it. Don't do anything that's gonna get it suspended. Any fine, any infraction to get,
Okay. Thank you.
take care of them. Don't let them go to, FTA. Signing an order with regard to the infraction, 25 a month is the payments. If, no, I don't know your financial circumstances, but if there's a problem making a payment, make sure we know that. Let us know, we can always deal with it. I just don't want it to go to an FTA where your license is jeopardized. Mr. Terrence, I'm gonna wish you good luck. You take care of yourself and have a good one. Congratulations on reinstating your license. And as I say, you have it, keep it.
Yep, definitely.
Take care of yourself. Yeah, and again, you can get a copy of this at the window and
Okay. Yeah, just a second. I'm on another 4 days.
that's all right. Mr. Everco, I'll defer to you. I think
We're done.
you do have the compliance with the SOC on that, the earlier case. But the city's they're not taking any action to revoke that at this time based on the disposition here. I think the city's happy enough, and I am, that you've reinstated your license. So that concludes the any court appearances you have for now. Keep an address on file, make sure we know how to get you just in case. Just in case we have to notify you of the court date.
Okay.
Any questions, Mr. Terrence? You have a good day. Take care.
Next man will be Robert Trevino.
Mr. Trevino, good. Phil, good morning. Sign here. This one.
So, Mr. Trevino, he has a couple of pretrial matters, and then I noticed there's a newer matter in arraignment. So what I thought we could do is submit a motion to continue on the pretrial cases, and on the assumption that we do the arraignment today and I'm appointed, we could
We can take care of.
consolidate the
address that
hearing
now.
of them together and deal with
Yeah.
them together.
Let's address that now. You know, I'm looking forward to mobile. I'm sure I'll wind up setting a pretrial on the arraignment case for the same date. How far out would you like to go?
At least 4 weeks, or if that, if that's getting full, then we can bump it out a little more. Let me double check with you. What's your number? Phone number?
You can go through the arraignment process.
Yep.
Sir, for the record, your full name is Robert Anthony Trevino.
Yes.
Trevino, the citation I have alleges that on or about May 27th, 2023, you committed the offense of criminal trespass, first degree. First degree criminal trespass is gross misdemeanor. The maximum penalty on conviction would be 364 days incarceration and or a $5,000 fine. Waiting Mr. Aberco to represent you on this case as well, and he'll enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, as court or not guilty plea.
We have not guilty has been entered on your behalf. We'll set the matter with the other trespass now. Condition of release is always law-abiding behavior, and so it doesn't do you a lot of good to get charged with the same offense again. I'm not gonna have you taken into custody. I'm not gonna make you set bail and post bail of any kind, but I am gonna remind you that law-abiding behavior is a condition of release. Sign the order, matter series set for July 20th. 11 o'clock in the morning, Mr. Trevino, you can get a copy of that at yeah, then this is with regard to docket numbers 11, 12, and 13. Okay, good. Okay, great. On this. Trevino, that's the dates of offenses are April 19th, April 22nd, and then May 27th. I hope everything's going well in life. Sometimes when I see things like this, they aren't. And I'm hoping all is going to go well with you. It is going well with you. Get a copy of today's orders by going to the window outside the courtroom to your left, and look forward to seeing you on the 20th of July. Any questions at all?
No.
Stay in touch with Mr. Everco and take care of yourself.
Thank you.
Thank you, sir.
Next matter will be Simon Rosnick. Oh, I'm sorry, Cyrus.
Cyrus.
A couple matters, one's a compliance matter, and one's a pretrial. I haven't had any contact. I think you have a number now?
Yeah, 253-888-3854. I had just gotten phone service again.
Oh, okay.
It was,
So we just, okay,
it was gone for about a month.
okay, gotcha. So submitting a motion for continuance, speedy trial waiver in there and just to reset things, so I have an opportunity to give Mr. Rosnick a call and talk about his case.
About how far out would you like to go?
Whatever's convenient for the clerk.
Rosnick, we're resetting your matter to July 20th, 2023, of course. 10 o'clock in the morning. It looks like community service is an issue on the other case.
I have had a question about that actually. So I just got kicked out of my mom's recently. I do have that paper. It's like I got it from I believe from you guys. For community service, it has it all written down on it. I have the 8 hours done, but I got kicked out and I lost that paper in somewhere. Is there any way that I could get a new paper and then maybe I'll just have to do it again or something? But I don't.
We can certainly give you the form again, I think. Yeah, if you go to the front window and ask for a community service proof form, and they'll certainly give you one.
Thank you so much. It's
those things happen. Those things happen. Mr. Rosnick, you take care of yourself. We'll see you back here July 20th, and hopefully you can get that done. We'll deal with it.
July 20th at 10 a.m.
Pardon?
10 a.m.
That is correct, 10 a.m. Yes.
All right, thank you.
Good luck. Get a copy of the order. It'll have the date, time, and conditions on it.
All right.
Take care. Back to the Drawing board. Any further?
No, there's no further folks here. I think we're just on to the no-shows.
We can always do that. We can always do that next. Let's do that. now.
On the 10 o'clock, John Katzavant, he's a co-defendant with number 7, Emma Benita Bell Moreno. I was
Yes.
actually able to speak with her. They weren't the friendliest discussions, but I made attempts to contact John Cassavant, which I believe they're maybe boyfriend, girlfriend, I think. Anyway, he did not call me back. I texted, I didn't get a return text, so I made an attempt to contact him, but I haven't had any contact.
And it doesn't look like Ms. Marino.
She's not. I did get her on the phone, but she said she was gonna show up today and let me know what she wanted to do.
Well, sometimes that city with Mr. Casman, city wish award.
Yes, 1,000 each.
Okay. And Ms. Marino, we've already heard from her, same with her. 1,000 cash or bond, so ordered.
And then on the 11 o'clock, as to item number 1 and 2. One
Mr.
being.
Bendio was just released on the June 2nd on his assurance that he would appear in court. Sometimes that doesn't work out.
Well, I was handed a note by the clerk and with his phone number, apparently he called and he said he was exposed to COVID, not coming in.
We don't want him.
So, I haven't spoken with him, haven't had any contact myself, so.
Well, I'd say give him the benefit that.
I'm giving him the benefit of the doubt. I don't, yeah.
It's a pretty big doubt. That was,
That's
that used to be
right.
a favorite way of keeping out of jail. I've been exposed to COVID.
I think,
You can't put me in.
I think people have maybe 3 to 6 months left of the COVID excuse.
Oh, hey. At my age and medical condition, I'm not gonna take a chance. So. It works for me. I may have a full year left.
Okay.
That's note the non-appearance for speedy trial purposes and I'll sign an order resetting the matter to, well, if he's been exposed to COVID, let's go July 20th, just for grins. Okay.
And the last matter, I believe, that's an O-show and the 11 o'clock is Mark Wilson.
Yeah.
I had, so I'd have to look at my notes to see. I think let's see, Wilson.
Do we need to order a video or just, yeah, it's good enough.
You know, I didn't contact him again. It's just because, he and I have talked previously and he had some pending felony charges. So I don't know. I didn't look up to see if there's something going on with that, but, we have been, tagging this case along after his, pending felony matters. And so I was gonna submit a motion for continuance on anticipation he was here, but I don't have any information as to his whereabouts.
Did he have a preference?
I prefer a warranty issue 2,500.
I think so. Yeah, I mean, so ordered.
Okay.
And let's go back to the 9:45. Ms. Lynn's did not appear.
Oh,
thank you, Donnie. as, this lens, it's my experience that's, when it comes to the, inhalers, the huffers, as they say, that's not good news. City wish it weren't, but that's docket numbers 4, 5, and 6.
Yes.
That's Kelly Renee Lenz does not appear. 1,000. I'm sure it doesn't matter. 1,000 cash or bond. Each case. Good afternoon. I'm going to call the 1 o'clock arraignment calendar. Before I address each case individually, I need to tell you a little bit about today's hearing. This is your first appearance in response to the issuance of a criminal citation. Typically, a plea of not guilty is entered. You set the matter then for a pretrial. It's a chance for you to review your case with your attorney and arrive at a resolution of the case if that's possible. If it's not possible, you have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. You do have a right to have a lawyer represent you at all stages of any criminal proceeding, including today's hearing. Mr. Haverco is here. Regardless, he will enter a plea on behalf of each of you and will represent you if you're indigent and request his representation. First call the matter of Antonio Jamal Hankins. Is that you, sir? Yes, sir. Citation I'm looking at alleges that on or about December 5th of 2020, you committed 2 counts of theft in the 3rd degree and 1 count of making a false statement to a public servant. Those are what they call gross misdemeanors. Maximum penalty on conviction to be 364 days in custody and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Thank you, Your Honor. Stipulate to probable cause, ask the court to enter a not guilty plea.
Mr. Hankins, a plea of not guilty has been entered on your behalf. That preserves your rights pending to pretrial, which we're going to set for July 20th at 11 o'clock in the morning. Conditions of release are always law-abiding behavior. And in your case, especially since given its age, appear for court as directed and maintain contact with Mr. Haverco. Mr. Hankins, any questions at all? Is it all in person court or is it? We have gone back to all in person. There's rare exceptions when somebody's out of state, circumstances do come up. For example, if you had COVID, I would probably want you remotely.
Is there possible to get an earlier court time in the morning? I work at the Port of Seattle and I start time at like 3 p.m. So is there like an 8 o'clock court docket or anything like that?
The earliest is 10.
Earliest we can go is 10.
Roger.
Yeah, let's change that to 10. All right.
Thank you.
And I need a phone number.
253 527 2147.
147. They'll give you a printed notice before you leave today.
Hankins, I'll sign an order on today's hearing. What I want you to do is go to the window outside the courtroom to your left, get a copy of it. And again, stay in touch with Mr. Haverco and we'll see you back here on July 20th. Any questions at all? Thank you for appearing. Thank you for your patience. Have a good day. And drive carefully to Seattle. Yes, sir. Courtney Amens, A-M-E-N-S. Good afternoon, then. For the record, is your full name Courtney, middle initial E? Is it Amens or Amens?
Amens.
Amens. Citation alleges that on or about November 12th of 2019, you committed the offense of criminal trespass, 1st degree. That charge is what they call a gross misdemeanor. The maximum penalty and conviction for that would be 364 days in jail and or a $5,000 fine. Are you asking for a court-appointed attorney?
Yes.
I'll have Mr. Haverco enter a plea on your behalf.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Simmons, a plea of not guilty has been entered. That preserves your rights. We're going to set the matter for a pretrial. And that will be July 20th at 11 o'clock in the morning.
And I'm reading that.
Yeah, 253, 733, 850.
Ma'am, I've now signed today's order. Please get a copy of the order before you leave at the window outside the courtroom to your left. Any questions at all?
No, sir.
Thank you for appearing. We'll see you on July 20th.
Okay.
And again, get a copy of today's order at the window,
Okay.
please. Joshua Archer in the courtroom. Joshua Archer. Now, a number of people will not appear, which is typical. What will happen is I will review the file at the end of court. There's a probable cause for the issuance of the ticket. I'll warrant issue for the arrest of the person. You've saved yourself a trip to jail by just simply appearing. For that, I thank you. Again, Joshua Archer did not answer. How about Jerry Bartlett? Mr. Bartlett, come on up and have a seat.
Thank you, Your Honor.
Full name Jerry Ray Bartlett. Citation alleges that on or about May 23rd, 2023, you committed the offense of driving while under the influence of intoxicants. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will have Mr. Haverco enter a plea on your behalf, Mr. Bartlett, and he will enter that plea, and then he's going to represent you throughout the course of the case, if that is required. Request.
Stipulate probable cause, Your Honor, ask Your Honor to enter a not guilty plea.
Mr. Bartlett, you do have a prior alcohol related offense. It's not amended down from a DUI, but it is alcohol related. Question is whether or not I should order ignition interlock. I'm not going to do that. The conditions of release are: don't drive unless you're licensed and insured. Don't drink and drive at all. That if any officer ever asks you to take a breathalyzer, you're to do so. We're going to set your pretrial. For July 6th at 11 o'clock in the morning.
You need to sign right here. It won't show it. And give a number, one number. 860 810 0912. Okay.
Mr. Barlow, that concludes today's hearing. And again, if you would get a copy. Yes, sir.
Do I still have my license?
Yes, I don't suspend licenses, but until if any action is taken against your license, that would be the Department of Licensing. Make sure they have sometimes I find that they've moved since they got their license. The Department of Licensing doesn't have a current address. Good idea to make sure that the DOL has your current address. And that the whole issue of suspension, that's something you could discuss with Mr. Haverco at a later date. Mr. Barlow, thank you for appearing. Good luck to you. We'll see you back here early July. You bet. You bet. If you would.
Yes, sir.
Jeremy Brissett. Shauna Carter. Jordan Cooley. Good afternoon, sir. Full name Jordan Patrick
Yes, sir.
Cooley. Mr. Cooley, the citation I have alleges in honor about May 30, 2023, you committed the offense of criminal trespass, second degree. That offense is what they call a misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. I'll have Mr. Haverco enter a plea of on your behalf, and he will represent you if you're indigent and you so require throughout the course of your case.
Thank you, Your Honor. Stipulate to probable cause, ask the court to enter not guilty plea.
Mr. Cooley, conditions of release, law-abiding behavior, appear for court as directed, and stay in touch with Mr. Haverco during the pendency of the matter. Pretrial is set for July 6th at 10 a.m.
Who wants it? One. He will be in just a second.
Really, that concludes today's hearing. Get a copy of today's order at the window outside and to your left, and you take care of yourself. Thank you for your Jared Cruikshank. Kinsey DeFord, expect no answer there. Brandy Ehrlich DeFord. Irving Flores. Tyler Keith. Is that Tyler Keith in the back? Yes. I think that, yeah. Hey, Mr. Haverco, I think that it might be Mr. Keith sitting in the back of the courtroom. Could you, but he's as you can see, we needed an ASL. Could you maybe point to him on the and find out if it is, if that is him? I'm wrong. I'm wrong.
Yeah, Mr. Keith, that's Mr. Madden.
How about Michelle Lyle? Michelle Lyle does answer. Sorry, sir. Ma'am, if you would come on up and have a seat. Is your name Michelle Nicole Lyle? Ms. Lyle, the citation I have alleges in honor about May 23rd, 2023, made a false statement to a public servant. That's a misdemeanor. The maximum penalty on conviction of 90 days incarceration and or a $1,000 fine. I'll have Mr. Haverco enter a plea on your behalf, and he will represent you throughout the course of the matter if you're interested. Mr. Haverco?
Stipulate probable cause, ask the court to enter a not guilty plea, and I don't know if the city was exercising the standing motion on the suspended case since it's tied in with this other case.
Sorry, that's I got ahead of myself. Ms. Lyle, you were also cited for a driving license suspended or revoked third degree. City has a standing motion to amend the that offense, which is criminal in nature, Conviction to bear up to 90 days in jail and up to $1,000 fine to a civil infraction. That infraction being no valid operator's license, second degree. If you admit the infraction, I'll assess a $150 fine. If you deny it, you have a right to a contested hearing. I may not have been perfectly clear on what I said. If you have any questions about anything,
I'm not guilty to the first one and then guilty to, if I plead guilty, it's $150 fine. Is that what I'm understanding?
on the criminal charge, that's no longer a criminal charge. You don't plead guilty or not guilty to that. You admit it or deny it. If you deny that you didn't have a license on you, we can set it for a contested hearing.
Right.
But if you admit it, I'll assess a $150 fine. That closes the case.
Okay.
Yeah, the problem is, you've got a criminal.
Do you have a phone number?
370
Yeah.
0873.
08.
Okay. So what that leaves you with, Ms. Lyle, is one criminal case for which we'll set a pretrial, and one infraction disposition, which will either set for a contested hearing or simply impose a fine.
Right, one more time.
What do you wish to do?
I will take the fine.
I'll take that as an admission and assess $150. And the question I have is, do you know what you need to do to reinstate your license?
Not exactly.
What I would do is I would check the Department of Licensing. You see, we live in a world where you pretty much have to be able to drive to function. And the most important thing to me in a case like this is that you reinstate your license. So I would check with Department of Licensing, find out what you need to do. And sometimes there's a lot of hoops to jump over. I'd start jumping if that's the case. But in the meantime, talk to Mr. Havercombe about that.
Thank you.
Looks like you have a warrant. Which could be why you're suspended. So, yeah, there you go.
And the pretrial is July 20th. Ms. Lyle, stay in touch with Mr. Havercombe. We'll see you back here then. Hey, good luck to you. Thank you for
You
appearing.
don't need to remember, just pick up a copy of the order from the clerk. It'll have a date, yeah.
Mike Mattingly. Mattingly, you're Mike Robert Mattingly Jr. The city does have a standing motion that does apply to you as well here. You walk in here charged with a criminal offense. City's amended that to a civil infraction. No valid operator's license, second degree. If you admit the infraction, I'll assess a $150 fine. If you deny it, you're entitled to a contested hearing, which we'll set for a later date. Any question about anything I've just said? What do you wish to do? That's I'll assess 150, that being the case. And then I'll ask you the same thing. You know what you need to do to reinstate your license? So that's more often than not, that's what it is. I would start, I'd work on it, and it takes time. In your case, we're gonna set the $150 fine at $25 a month. And yeah, this won't have any effect on your license unless you skip a payment. We don't hear about it. If financial circumstances don't allow you to make a scheduled payment, please let us know. And that is something we can, that's something we can deal with and take care of. But if you don't let us know, it goes to the, you know what happens. It goes to the department as a failure to appear. Schematically, I'm signing an order setting the payments at $25 a month. Get a copy of that at the window outside the courtroom and to your left, and that'll take care of the matter. Thanks for your patience. Sorry for the mistaken identity, and good luck to you.
Thank you, Your Honor.
Thank you, sir. Stephen Morris. Mr. Morris, good afternoon. You're in the same position. You were cited for driving a license suspended or revoked 3rd degree. And the city has a standing motion to amend that to the civil infraction of no valid operator's license. If you admit that infraction, I'll assess a $150 fine. You also have a right to deny that you committed the infraction. In which case, what I'll do is set the matter for a contested hearing sometime down the line. And any questions about anything I just said?
No.
What would you like to do?
I'll just admit to it.
I'll assess 150. And Mr. Morris, you can pay that off at the rate of $25 a month.
Okay.
And again, you just heard me say this. If you can't make a payment, let us know. We can deal with that easily. We can reschedule, reduce the payment, whatever. We'll handle it. But if we don't hear from you and you've missed a payment, that has a bad result.
Okay.
That adds to the misery.
Do I need a
You
sign?
don't say.
Okay. Thank you, Your Honor.
And a copy, Mr. Morris, you can get a copy at the window.
Have a good day.
Hey, you as well. Good luck reinstating. And this is, are we two?
Last name was Marino?
What is the last name?
Marino?
Yeah, Ms. Marino, good afternoon.
Oh, you were scheduled for 10 o'clock.
That was this morning.
Yeah.
Oh, no. I swear, one of.
Here's Mr. Cassavant.
Well. Ms. Marino, yeah, your matter was scheduled for 10 o'clock this morning. We haven't printed it or sent out a warrant for your arrest yet, but Travico,
I mean, yeah, I mean, I would ask.
as long as,
Here, she's late, this, I think the FTA remains noted for purposes of speedy trial purposes, but I would just suggest the reset.
Ms. Marino, rather than issue a warrant, let's just give you another court date, okay? Honey, is that something we need a form for, or? What I want you to do, Ms. Marino, is go to the window outside the courtroom to your left, and you'll be given a notice to appear on June 22nd at 10 o'clock. Always a good idea. Stay in touch with your attorney. Always a good idea to touch base, at least a day or so before court to make sure you're both on the same page. And we'll see you back here 22nd of June.
Okay, thank you.
Thank you, ma'am.
Why don't you come on up? Is your number 360-960-9475?
Yeah, we just got turned back on.
Oh, did, okay.
And who is this?
This is John Cassavant. He.
Oh,
had
Mr.
also-
Cassavant.
Yeah, he had billed up here at 10. I don't think your honor has issued a warrant yet, but he's here now. I would.
Ordered one, but has not been
Yeah,
issued.
would ask the court to not, to not issue the warrant, and to, it's an FTA for purposes of speedy trial. He and I haven't had a chance to talk about the case. I would ask to reset it. His phone was not working. Apparently now it's not working, so. It's working. Okay.
Mr. Cassavant, yeah, we did order a warrant for your SB and haven't had one issued as of yet. It's always a good idea to make sure you're in court on time, but hey, things do happen, I realize. We'll just simply reset the case to a later date.
Okay, thank you. Yeah, we just spaced the time, both of us.
June 22nd, 10 o'clock. That's
All right.
that'll same.
Okay.
And that's simply a notice that will be handed to you. That'll be at the window outside the courtroom and to your map.
Okay.
Mr. Cassavant, thank you.
What's that? Oh, she will be here? Oh. 2 minutes? Sure.
We'll
Okay,
see. That's,
so it's 1:28.
nobody's left in the courtroom. My. Good afternoon, ma'am. I need to verify for the record, your name is Janet Marie White. Ms. White, go ahead and have a seat at the council table, if you would, please. And good afternoon. Ms. White, you're here on two matters. Let's deal with the arraignment first. I have a citation that alleges that on or about April 13th of 2023, you committed the offense of assault in the fourth degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Havergo to represent you on that case as well, and he's going to enter a plea on your behalf at this time.
Stipulates probable cause, Your Honor, ask the court to enter not guilty plea.
We have not guilty has been entered on your behalf, Ms. White. You are also brought in on compliance with a diversion on a fourth degree assault matter dating back to data violation of 8/11/22. Take note, we'll simply calendar that along with the criminal citation. We're going to set your next hearings for July 6th at 11 o'clock in the morning. They'll give you a copy of the order. And do you have any kind of phone number or anything? Cell phone? What's that? This way to condition of release is law-abiding behavior, stay out of trouble. Are you reachable at all right now?
My friend sort of with me, and so I have this one. It's really hard for me. Like, if they stole my cell phone, I just got a new cell phone. I paid $250 for it, and now I don't have anything. I have nothing. IDs and social. So my boyfriend,
What's the
Back on record for the 1 o'clock no-shows. The first one I have is docket number 2, page 17. Find probable cause for the issuance to Joshua Archer, Crumtress 2 and obstructing 1,500 cash or bond. Next would be Jeremy Brissett. Find probable cause for issuing to him a citation for theft third on data violation 5/25, 1,500 cash or bond. Shauna Carter, docket number 5, probable cause is previously found for citation for assault in the 4th degree, 1,500 cash or bond. Next, I have Jared Crookshank, docket number 7. DWS third, amend that to no ball 2 and FTA. Going to the next page. Kinsey DeFord. Oh, it was just released by Paul Pro Tem. Find probable cause for oh boy, enough. Docket number 8, Crim Trust 2. Docket number 9, Crim Test 2. Docket number 10, Neg 1. And docket number 11, mitigation hearing. On the 3, go in the FTA, the infraction that on the first 3, 1,500 each. The next is Brandy Lynn Ehrlich DeFord. I do find probable cause for DWS third. Ordinarily, that'd be amended, but I think given that note on the file, probably just a reset with notice. And any indication of what the hospitalization was about, and just that she was in. With the Hilburn Act, you can't, HIPAA compliance, et cetera, they can't tell you. Next, I have docket number 14, Irving Flores, do find PC for DOS third, but amend to no vol 2 and FTA. The next one, docket number 16, Tyler Keith. The city's moved to dismiss that as a case management decision. I signed the dismissal order of that. Next, I have Mike Mattingly. We did that one. We did have that one. Then yes, both 21 and 22 did not appear. Sarah Richards and Cooper Thompson amend both of those to no vol 2 and FTA. Gina White did appear. There's a motion to continue. That's since it's agreed to by the city, kind of hard to back out now. And yeah, do we need a parent state in that? Okay. Do I have to close it up? I do. Close it. Done. Continue. With the prior, we should, I think they should interlock, but kind of hard to do that. Is it ready to go? That's it. Okay. go ahead and sign or send to Mr. Thompson, we're scheduled for 1 o'clock. It's now going on 2:30, it looks like.
Oh, it was 1 o'clock?
It was, yeah, 1 o'clock. You were cited for driving a license suspended, revoked, 3rd degree. The prosecutor's gone, the public defender's gone, but the city has a standing motion to reduce this criminal charge, which if convicted bears up to 90 days in jail. They amend it to a civil infraction. The civil infraction is one where you're not entitled to a lawyer. All you're entitled to do is ask for a contested hearing, pay the ticket, or ask it to be mitigated. If you admit that you didn't have a valid license on your person, that's called NVOL 2nd degree. When you're cited on May 27th, I'll fine you $150 and that'll close the case. Any question about anything I just said? Okay, then that's exactly what we'll do. I'm going to sign an order setting your payments at $25 a month. Now tell me this, do you know what you need to do to reinstate your license?
Yes, I've already paid it and
Wonderful.
So, they said that the DOL should, is releasing it today. They should got something from the Thurston County Courthouse. So.
Perfect, perfect. That's as you, I'm sure you're well aware now, it's pretty easy to lose your license, and a little tougher to get it back. So now that you have it back, make sure you keep it. If you get a ticket, make sure you show up for court and take care of it. Always a good idea. Any questions at all? I'm signing an order. Your payments will be $25 a month. The first payment due July 8th, next month. Now, if you have trouble making a payment, don't just ignore it because that'll lead to another FTA on your record, which will suspend your license. Let us know. We can deal with that. We can forgive payments, set them over, give you more time, community service. There's other things we can do, but don't just forget it. Any question at all? Mr. Thompson, I'm signing an order of setting the fine at $150. I want you to get a copy of today's order by going to the window outside the courtroom and to your left. They'll give you a copy of it. Look it over carefully, and if you have any questions, give us a call.
Okay.
I want to congratulate you on taking action to get your license back. And as I say, now that you have it, keep it. Any questions, sir? Good luck to you.
Thank you.
And always a good idea to check the time of your court date to make sure, as luck would have it, we're still in session and have something else to do.
Yeah.
Good luck to you.
Thank you.
Thank you, sir.
Hi, good afternoon. Can you hear us? Okay, press star 6 to, there you go. Okay, so.
Got it. Sorry, but yeah, I didn't know. I've never used the phone before. I've always just used the computer.
It works, so let me go get Judge Meyer. 1 sec.
Thank you so much for the patch up job here.
No worries, 1 sec. Oh, he's coming in.
We're not on record yet. Martin, how are you?
Oh, Tom, I'm fine, thank you. I'm sorry I didn't come down there. You know, I don't know about you, but I think maybe our time may be over with this law stuff. It's just gotten too technical, hasn't it?
Well, I think you're as much of a computer dinosaur as I am, or at least as in it.
No, I'm worse. I just can't. I break out in hives every time I got to look at a screen.
Yeah. I think, well, if you were here in person, I've got some stories. I just got back from that judges conference over in Spokane, and I could not agree more based on that, I'm glad I'm at this end of the trail, not the beginning.
That's all they talk about, isn't it? And these young ones, and you're thinking, you know, when we used to go to court, we'd talk to prosecutors about legal issues and facts and cases, and now all these folks do. Yeah, I mean, you go to different courts, and these prosecutors here in Pierce County, the ones on the record in court, they're hiding behind their screen. They're constantly typing. I said, turn it off. Get the vibe of the courtroom. See what's going on. I'm glad we're almost done.
Well, I could vent for another half hour, but let's go on.
Yeah. No, I got to be in Thurston in a little bit, so thank you.
Let's go. Now on record, I'm going to call the matter of Yelm versus Jeremy Wilson. It's a infraction here for contested hearing. I've read the 4-line, almost 5-line, and I can anticipate exactly what the motions are. But Mr. Duenhalter, I'll defer to you.
Thank you, Judge Meyer. May it please the court, Martin Duenhalter on behalf of Mr. Wilson today, and I thank the city for sending me the discovery, which I have, which is the officer's narrative in the front and back of the ticket. What I'd ask the court is basically on the speeding. There seems to be no measure there. Well, there's so many issues, but the easiest thing to say is there's no foundation for this speed measuring device in that we would need to have a number or something, or a manufacturer even pursuant to 6.6, because you can't figure out who is it approved? I mean, where do you start? If you don't have the number, you don't know if the city of Yelm is using it, whether or not it's ever been working or not. So I would suggest to the court there's an element missing here, and that would be the number of the speed measuring device, so we could go further and find out if it's in fact a radar, laser, or a carrier pigeon.
I'm going to grant the motion on that. For all I know, is a stopwatch. I have no idea what the SMD was, much less it doesn't comply with 6.6. I'm going to dismiss the speeding.
Thank you, Judge Meyer. And regarding I think you got another one for expired tabs. And so I read that, and the foundation that the officer testifies to is a traffic stop was conducted, and listed driver was issued a citation for speed and expired tabs. The foundation for that would have to be I ran my computer, or I looked at his license plate, or some observation and then some use of the English language establishing that in fact the tabs were expired, and what the base of that knowledge was under evidence rule 602.
I could not agree more. Simple assertion that the tabs are expired is a conclusion. I need facts upon which I can base a conclusion and make a finding. I have none. So I'm going to find in your favor on that as well. Both citations or both infractions will be dismissed.
Thank you very much, Your Honor. Will the court probably doesn't send out orders, or I could just make a note?
I'm signing one right now, and we'll send you one. That always looks.
Oh, I love it. I still like paper, Your Honor. I sure appreciate it.
I'm electronically signing it. I have to click on a signature now. I can't use an ink and pen. That's the way it goes.
Well, just make sure that no rhesus monkey gets in the courtroom in the middle of the night and starts clicking your signature on everything, and then I guess we'll be okay.
Well, someday that's bound to happen.
It is, Your Honor. Your Honor, it's good to hear your voice. Thank you very much for hearing my matter today. I appreciate it.
Duenhalter, it's good to talk to you as well. Hopefully next time it'll be in person.
That's exactly right. Thank you, Your Honor. You guys take care, and very much thanks to the court clerk for working through the technical difficulties with me.
You're entirely welcome. You take care.
You too. Bye-bye.
Bye. With that, we'll go off record. It's well now after 2:30, Jaden Paulman did not show up for the contested hearing. She requested with regard to an open container. Ordinarily, I would issue an FTA and that, or have an FTA issued. I've reviewed the officer's statement, and the officer's statement doesn't comply with the statutory elements. I'm not going to enter an FTA for a infraction for which there's a complete and full defense. I'm going to dismiss the infraction on my own motion. And with that, we'll go in recess.